Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped planned communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
I'm going to let all of you start joining the class today, but I'm first going to make some introductory remarks. So welcome to everybody. Today is our October 1st Fridays for 2025. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. Welcome to our firm's live virtual First Friday event for the month of October 2025. Our firm currently represents over 1,000 planned communities and condominium associations in Arizona. I also currently serve on my HOA board and have for many years. Here's how First Fridays is going to work today. If you haven't already done so, we have about 40 questions already. Please submit your First Friday question in the Q&A box on Zoom or in the comment section on Facebook Live. Please do this as soon as possible, and then we're going to try to answer all of these questions in the next hour. Just a quick friendly reminder, due to the large volume of questions that we get, this opportunity is limited to one question per association. If you plan on submitting a question live during the session, please include the name of your HOA or condominium and your current role when you submit the question. Also, please try not to make the question too long and complicated and too specific to your association, because I usually can't answer those because it's usually like 5-part questions sometimes we get, and it's really difficult to answer those type of questions in this type of a quick forum, question and answer forum. Thank you for understanding. Okay, let's start out and talk a little bit about the new Arizona legislation. So all of this legislation has gone into effect on September 26th. And so we've been talking about this now for many months since the legislature adjourned on June 27th, 2025. So I just want to give a quick recap today or this morning because these laws are now effective. So we are bound by them. Let's talk a little bit about the first law, and this is Senate Bill 1039, which again is the law now. It applies to condominiums and planned communities. And basically what this says is that if the board records, it could be by Zoom, it could be on their phone, it could be a video recording, audio recording, whatever. If the board records an open board meeting, a copy of that recording must be kept for at least 6 months. And if an owner wants to see a copy of that recording, the association has to provide an unedited version of that recording upon an owner's request. The next bill is Senate Bill 1370, and this talks about political signs. And basically what it says is that it changes the definition of a political sign to include a sign or a flag. So now political flags are subject to the same laws that a political sign would be. So, I mean, obviously that's a sign of the times. With the last 2 presidential elections, we definitely saw more flags with a political nature. And so you're going to be subject to the time restrictions as to how long those political flags can be up and when they need to be taken down, sizing of the flags, et cetera. And again, this law applies to both planned communities and to condominiums as well. Okay, the next one is Senate Bill 1494. This talks about common expense liens and a foreclosure amount. This applies only to planned communities. It makes it just a little bit more difficult for planned communities to foreclose an assessment lien. And basically what the old law said was that the assessment had to be either 1 year delinquent or $1,200 owed in assessments only before we could foreclose. Now, the new law, which is the law right now for planned communities only, is we have to wait either 18 months or have the dollar amount that's owed to be $10,000. So I think kind of for planned communities, the key thing is going to be, it's going to be very unusual to have it get to the $10,000 mark. So it's going to be probably, we will wait to foreclose until it's 18 months past due. The last bill that we're going to talk about is House Bill 23. And this basically gives us more definition with regard to commercial condominium associations and helps us better navigate how to define them and expense structures, et cetera. Most of our clients are not commercial condominiums like a dentist's office or a lawyer's office where they own office space, but just be aware that there is has been a clarification for office condominiums or commercial condominiums. And if you are one of those associations, you need to brush up on that new law. Okay, let's talk a little bit about our questions now. So today we have 40 questions as of 9 o'clock. So we're going to pop right into those questions today. The first question, what do homeowners and board members do if a majority of board members vote in favor of giving a $1 million contract for AC replacement to a company that does not have the proper license? Can we request a judge to issue an injunction so the contract is not signed until the issue is resolved? So I think this question kind of goes to the heart of, is a contractor licensed, bonded, and insured? And I think it's important that it's confusing when you go to the Arizona Register of Contractors website and you look up the name of a contractor, and sometimes they have 5 or 6 different licenses. So what I would recommend that you do is bring your concerns to the association's board and ask for a response, a written response from them. If the response isn't forthcoming, then you could consider, contacting the Register of Contractors and finding out more information. There's a great online portal that you can do that. I mean, obviously, any board that feels that or any owner that feels that their board is making a poor choice, there are a number of different places you can go. The Arizona Department of Real Estate has a division that hears complaints between owners and associations. You can hire a lawyer to write a letter. You can express your concerns in writing to the board. If you don't want to spend any money, you could go to the board meeting, express your concerns verbally at the board meeting during the homeowner forum, or kind of last choice, I mean, not that it's the last choice, but just the last option would be to have an attorney file a lawsuit on your behalf on this matter. Okay, next question. What do homeowners and or board members do if the request for proposal process is contaminated because the committee chair is providing information to one company that she favors and not providing the information to all companies that are participating in the bidding process? Ooh, that's not good. That's definitely a breach of fiduciary duty, in my opinion. I think probably what you need to do is take that person out of the equation, if that is in fact true. I'm only hearing one side of the story on this, but we have a great cheat sheet on bidding and contracting that I would really encourage you to take a look at. And our office is going to be sharing that with you shortly. I also would like to just give a couple suggestions here on the bidding and contracting process. If you have a situation where you're bidding out, I don't know what your RFP proposal process was. It sounds like you had a committee handling this. You may want to send it to your attorney or our firm to help you with that. And basically, the RFP should have all the information listed on it in terms of how the bidding is going to take place. There should be no communications between committee members or board members with the contractor that are not authorized. So you shouldn't be saying, oh, if you bid at $2,000, I think you can get this or whatever. I mean, that's just totally inappropriate. It's like bid rigging, and it's definitely a breach of fiduciary responsibilities to the corporation. So what do you do in this situation? Number one, I'd take that person out of the equation to help with this bidding process. 2, you might need to bring in an independent company, whether it's your management company or your law firm, possibly even your CPA, to help you manage the bids. I'd make sure that they're sealed. I wouldn't allow to have communications that are unauthorized with any of the people that are bidding. So those would be just some suggestions as to what board members can do if an RFP process has been contaminated. Okay, next question, number 3. Is there a requirement to keep your reserve funds in a separate bank account than an operating account? What is best practice? Okay, so there's no legal requirement under Arizona law to do this, but best practices would definitely be to do this. Keep them in 2 separate accounts. Also have your CPA weigh in on this and see what they say. I'm assuming they will agree with me. And we also have a great cheat sheet on the topic of reserve studies and reserves that I would encourage you to take a look at since this is a topic of interest to you. Okay, question number 4. The head of the ARC committee is the president. There was a vacancy and she appointed her husband. Other than this looks bad, is this permissible? Well, it really depends on what your documents say in terms of who can be on the ARC. Well, first, as you said, a board member, Arizona law requires that a board member be the chair of the ARC. So having your board president as the chair of the ARC is totally fine. And that's, in compliance with the law. It could be any board member. But appointing the husband or a relative or maybe like somebody else on the deed, it really smells bad and it's not a good idea. I doubt that your documents are going to say anything about this other than the committee members can be appointed. It might even say committee members must be owners. It's just not good because the balance of power is shifting, meaning like one lot owner is making the decisions via two committee members that affect the entire community. And if I were the attorney for the association, I would really advise against this. Let's see. Next question, number 5. We had to condense this one because it was really long. So number 5, let's see here. Is it legal for our 55 plus HOA board to announce Zoom-only meetings just on the website and on the bulletin board if they discontinue posting sandwich boards at the entrance? Many owners, including some without computers, may miss these notices. Are there any requirements for hybrid or in-person options, and what best practices should the board consider to ensure all members can participate? Okay, so we have a couple great cheat sheets that will help you kind of navigate this question. We have one on board meetings, and we have one on tips for conducting virtual board meetings. Here's the 411 on board meetings, especially post-pandemic. So the key is that any open board meeting is where we have a quorum of the board members present discussing association business. And when you have that situation, you have to give 48 hours notice to the membership. The statute really doesn't give us a lot of direction in terms of what qualifies as adequate notice. But I do think the notice that your board is giving on the website and also on the bulletin board is adequate notice. If in the past they also did the sandwich boards, which are like the plastic signs that are like in a triangle shape, maybe there's a reason why they stopped doing that. Maybe they're getting damaged or maybe they're getting blown over. I don't know. I mean, you certainly have a right to express your concern that they're not doing it anymore, but ultimately it's the board's decision. And I do think that the way that they're providing notice is adequate under the statute in Arizona. Let's see. So yes, what they are doing is legal would be the short answer. Even though you don't have computers, you still have the right to see the bulletin board. And of course, you can express your concern on this to the board and see what they say, why they decided to discontinue sandwich boards. Are there any requirements for hybrid or in-person options? Really, since the pandemic is over 5 years ago now, most boards are doing either hybrid or all virtual board meetings now on Zoom. That is the norm. I mean, I hardly ever attend board meetings in person. As a matter of fact, I can't think of one that I've attended in person in the past 6 months. So it's a rarity now that I attend in person for a number of reasons. Most boards are meeting by Zoom. I think the pandemic was a game changer. People realized that business could be conducted without having bodies physically there in person. So there are no requirements right now under Arizona law. It doesn't say like it has to be in person. In fact, the law, even pre-pandemic, allowed for the board to conduct meetings via conference call or any other means. I think that the way before Zoom, there were some other ways that, some boards rarely would meet that way. So I think it's perfectly fine to have hybrid, all virtual or all in person. It just depends on what works for your association, and the board ultimately makes the decision on that. Of course, they should consider the feedback of the owners, but ultimately they do make the final decision on that. What are best practices? Just listen to your homeowners and see how they're feeling about it. Even though the meeting may be by Zoom, the board really should be providing an option for homeowners, if they want to come in person, have a location or venue where the meeting can be live streamed, maybe at the management company office or at the clubhouse or something. So if people really want that in-person experience, they can go and watch the live stream. And really, anybody who has a phone can participate in a virtual meeting because Zoom allows you to also dial into the meeting. Okay, next question, number 6. Our governing documents do not specify committee membership eligibility. Can or should the community manager be one of the 2 members of the governing documents committee? Ooh, that's kind of interesting. Lots of questions on committees today. So I think it's unusual that the manager would be an active member. They're going to be more like a supporting role, like our firm would be, as well as the management company. We're supporting the board. So I probably would shy away from having, if you're only going to have 2 members on the committee, having one of them be the manager. I don't really think that is something that I would encourage. They're having a supporting role, and as would your attorney, but I wouldn't recommend that. We also have a great cheat sheet on committee basics that I'm going to be sharing with you, or my office has already shared with you today. Okay, question. What are the requirements for board financial reviews, and should details be available to homeowner board meeting attendees? So great question. Under Arizona law, and this applies to both planned communities and to condominiums, an association is required to have an audit review or compilation at least annually. And that if the documents, usually it's in the bylaws, require the audit to be done by a CPA, it needs to be done by a CPA. If the documents for your association do not have a specific requirement for a CPA to be involved in the audit review or compilation, then really the board can do a number of different things to satisfy that requirement under Arizona law. They can have a bookkeeper do it. They can have an accounting office do it. They can have a board member do it. They can have the management company do it. They can have a committee do it. They can have somebody in the community with financial experience do it. There's really kind of no set rules on that. Now, obviously, best practices would be for an independent party with expertise to do that review. Most boards that have the financial ability to do so are having an audit every year. Most boards are on a fiscal year that ends December 31st. So they need to have the audit completed by a CPA by June 30th. And then members can request to see that audit starting July 1st. Actually, they can make a request for it starting July 1st, and then we have 10 business days to provide the documents to it. Most audits, unfortunately, it takes a long time to get them. So like literally my association, we had an audit done on our financial records for 2014. We just talked about the report last week, the financial report that the auditor gave us. And remember, when you have an audit like that, make sure your board's talking about the audit when you get the report back at an open board meeting, and read through those comments, because that's where the auditors put all the information about what the problems are financially in your community and what sort of financial controls may need to be in place so that there isn't fraud or embezzlement or whatever in the future. So short answer, what are the requirements? I think I got over that. Should details be available to homeowners? It should be discussed at a board meeting. Also, every month at your board meeting, there should be a discussion regarding the financials. The treasurer should give a report, or the management company should give a report regarding the financials. Homeowners are always required to request to see the audit or the financials of the association. They just have to make a request in writing, and the association has 10 business days to provide it to the homeowner. Okay, next question, number 8. We had to condense this one too. Can our HOA amend the CC&Rs to ban future short-term rentals, given that one rental is causing rule violations? Does this require a 2/3 homeowner vote per our CC&Rs? Or are there new Arizona laws that limit HOAs from restricting short-term rentals? Ooh, this is like a loaded question. Hard to answer in a short period of time. But short answer would be check out our cheat sheet on amending CC&Rs and implementing rental restrictions, because we have a lot of great information in there on that. Without seeing your CC&Rs, without knowing specifics about what type of association you are, whether you're an HOA or a condo, you're saying you're an HOA, but I would want to verify that in your documents. It's really hard for me to comment on this topic. There is a case called the Colway case, which definitely makes it more difficult for associations to implement a rental restriction like this. It does not make it impossible, but it does make it more difficult. So I think the best practices here would be, I need to look at the CC&Rs. I'd like to talk to you about the meaning of Colway and how it may apply to your association. I'd like to talk to you about possibly using grandfathering to kind of navigate our way through the Colway ruling. So reach out to my firm and let's talk more about this. But I am going to say it's not the easiest thing to do, but I think we could come up with different options that will help you navigate this problem. Also, remember, if you have a bad tenant, the best way to deal with the tenant is make it hurt in the pocketbook of the landlord. So you should be sending that file to your attorney. The attorney should be contacting the landlord. There should be fines being levied for violations of the documents. And really, every time our firm is contacted and there's a problem with a tenant and we contact the landlord, we get it done. You just have to push the right buttons to get the doors open, okay? The landlord gets it. They don't want to have a tenant that's going to cost them money in the long run. They're in the business of leasing their property so they can make money or break even, pay off the mortgage. So we know exactly what needs to be said to the landlord, specifically, hey, if this continues, this is going to end up costing you more money in legal fees and fines. And it's not worth it. Either get your tenant's behavior under control or we are going to go the legal route and this is going to cost you a fortune. And I can pretty much guarantee you that's going to solve the problem. Okay, next question. I'm a new board member. Our management company provides financials 2 months late, even though our contract requires reports by the 15th of the following month. How can the board ensure management companies with the contract deliver financials on time? Okay, a couple of things. It worries me to hear that the financials are late. I want you to look at our cheat sheet on fraud and embezzlement. I'm not saying that's happening here, but one of the warning signs is that the financials are always late or way behind, like 6 months behind. So just keep that in your back pocket. Hey, that's a concern. And we have a cheat sheet on the warning signs, so please take a look at that. Okay, so what's the best way to get this done? I mean, go to the president of the management company and say, hey, this isn't happening. We want to know why. Maybe there is a valid explanation. Like, I know that the bank statements don't typically come until the first or second week of the month, sometimes the third week of the month. And so maybe there's a lag because they can't do it until the bank statement comes. But the key thing is communication. The management company knows that they have obligations under the contract and they should be living up to them. So this shouldn't be too difficult. Okay, next question is condensed as well. Our HOA is gated with private roads. And while our CC&Rs and rules address street parking, they don't cover vehicles parked facing the wrong direction of traffic. This creates unsafe situations. For example, we nearly had an accident when a car pulled away from the curb while facing the opposite direction. Does Arizona traffic law apply on private roads, or would the board need to add specific language to the rules to address this? Since you're a gated community and it's private roads, the best way to do this is to create a rule. You may want to contact our office because we got to check out how broad your rulemaking authority is and help you with the language on it. But yes, I would definitely do this right away because we have seen instances, even like in the past 9 or 10 months, where unsafe parking on the street, not specifically your situation, but like parking trailers, construction equipment, has resulted in serious injury or death to owners. So it's not something to fool around with. So I would definitely get on that right away. Okay, next question, number 11 from a board. If we are having trouble with our bills being paid in a timely manner from the company managing our finances, is that considered a breach of contract? Well, I'd have to see what the contract says, but generally speaking, yes. I mean, if you're hiring them to do this in a timely manner, they should be doing it in a timely manner. I think I'm just going to ask my office to make a note on this. I think we need to either write a Mulcahy memo or a newsletter or something, or maybe a new cheat sheet on management company relationships, because we've had a lot of questions on that today. And what's the best way to navigate when there's problems? So I would go back to the management company, the head of the management company, and talk about this issue and say, this is not appropriate. If there's any fees that are extra, they should be paying it if they didn't pay it on time, if it's truly their fault. Okay, next question from a board. As a condominium, is there anything we or legal representation can do to speed up the foreclosure process on a mortgage or a reverse mortgage? Are there things we can specifically do? Well, okay, a couple questions. I'm not sure if you're talking about the association's foreclosure process or if you're talking about, the mortgage company or the first deed of trust foreclosing, or maybe the reverse mortgage foreclosing after somebody passes away. So it's kind of hard for me to answer this question. If it's a foreclosure process that's being managed by the association, meaning we're filing it, we're pursuing it, just make sure that the attorney's on top of it. I had a call this week where another firm, a board asked me to review another firm's work, and they were just too many delays. It was taking too long. I could just look at the file and be like, okay, they're not pursuing this diligently. They're not moving forward and checking the file every 2 weeks and taking the next step. So if it's your association foreclosing, yes, there are some things that you can be doing to make sure that things are getting done in a timely manner. Have an attorney that understands collections and is on it. That's probably the most important thing. Now, if you're asking this question for a third party foreclosing, it's difficult because we have to be careful. As an attorney, I have to be careful not to be contacting a third party regarding the debt of an owner. But what we have done in the past is maybe have the association send a letter directly to the mortgage company or the reverse mortgage company and apprise them of what's going on. Maybe there's water intrusion in the association, or maybe the owner's deceased, or maybe the property's unsecured and there's homeless people living in there or whatever. So we can help you strategize if you contact our office on the fastest way to get their attention so that they move a little quicker. And that does happen. If we contact them and their property is unsecured or they aren't aware that the person passed away or whatever, getting to the right person at that foreclosure company or the mortgage company or the reverse mortgage company can get things moving along. So contact our office if you need help with that. Next question, can a board add to the agenda a new item during an open board meeting by making a motion and obtaining a majority vote of the board members? So we're going to share with you our cheat sheet on board meetings. Generally speaking, yes. Things come up at the last minute all the time before a board meeting. I know that because I've served 14 long years on my board. We try our best to put in the agenda and notice that we send out 48 hours in advance of the meeting, what's going to be discussed. But there are times when, things come up. So I don't have a legal problem with that, would be the short answer. Okay, question number 14. Our HOA board hasn't enforced some CC&R's restrictions for many years. Is there, let's see here, so to make sure that we've still got a good connection. Okay, perfect. Our HOA board has not enforced some CC&R restrictions for years and may grant grandfathering to longtime violators. Does the board have the legal authority to override homeowners' CC&R's violations by not enforcing or by approving by grandfathering? If not, what options do rule-abiding homeowners have? Okay, so it just depends on what the violation is, but generally speaking, yes. If a violation has existed for more than 3 years, the board is likely unable to enforce that violation because they waived their right to enforce it. It's frustrating to rule-abiding owners because they are following the rules and now they got to look at this shed that they never wanted in their line of sight on their neighbor's yard. So, I think kind of the rule of thumb here would be if an owner sees a violation and maybe the board doesn't see it, make sure that you're contacting the board and saying, hey, are you aware of this violation in a timely manner? Because if it gets to that 3-year mark, you're not going to be able to enforce it. The board's not going to be able to likely enforce it. Okay, next question, number 14. We had to condense this one. Number 15, excuse me. The next question is, our HOA mandates 2 coach lights on every home exterior. One resident has chosen new lights that, when viewed, directly look like iron crosses. We don't want to set a precedent of having religious symbols permanently attached to homes, but our architectural guidelines don't address this. Do we have any recourse to deny these lights? I'd have to look at what your section in your architectural guidelines says, and I'd have to look at a picture of the new fixtures just to kind of weigh in on that a little bit more. Hard for me to talk about that without seeing what your documents say and then also seeing a picture of the lights. But I'd be really careful on denying it based upon the fact that it's a religious symbol. I think that's going to be potentially problematic from my point of view because there are some federal laws that we need to be aware of that we can't discriminate against owners. And so I think that's one you're going to have to contact my office so that we can talk a little bit about this. Okay, number 16. We have a homeowner who believes that patio covers without solar panels meet the definition of a solar energy device in Arizona state statute. Do patio covers without solar panels meet the definition of a solar energy device? Are they subject to 33-18? So we have a great cheat sheet on solar panels and creating green communities. I would encourage you to take a look at that. I'd have to see a picture of the patio cover. I don't know what's on top of the patio cover, so it's really hard for me to comment on this just by this question. So I'd have to look at your documents. I'd have to look at what the patio cover looks like and maybe even consult with a solar expert to see if it meets the definition. So can't really answer that question without having more information on it. The definition in 44 ARS 44-1761 is pretty broad. So it's possible it could be considered a solar energy device, but unlikely. Okay, next question is number 17. From a board member, we have a self-managed HOA. Our complex has 119 units and it's almost 50 years old. Would it make it easier to take care of this complex if we hired a property manager? What is your opinion? It's really up to you whether or not your board is ready for a property manager. This is probably going to entail kind of having a lengthy discussion with me because typically what I hear from associations that are your size, 119 units is kind of pretty large for the board just to be managing it. It just depends on what type of problems you have. It sounds like you're 50 years old, so you probably have some deferred maintenance that's going to be an issue. So I think you're probably leaning towards now that, hey, we need a management company to come in and help us manage things because we need to do some capital improvement projects that are going to require expertise and time and energy. It's something we should open the discussion on. And I can maybe refer you to some management companies that I think would be a good fit based upon your needs, where you are geographically in the valley, et cetera. Okay, question 18. From an owner, we had to revise this one a little bit to make it a little bit more understandable. What percentage of homeowners is needed to approve a CC&R amendment to change the minimum rental period from 30 to 90 days if the current 30-day minimum is only stated in the rules and regulations and not in the CC&Rs? So again, lots of questions on these rental properties and amending CC&Rs. So my office, we got to take note of this. We got to start writing more answers and articles on this. I really have to see the CC&Rs and the rules before I can take a look at this and give you my thoughts. In terms of, I don't know if you're a planned community or if you're a condominium. I don't know. You said that the 30-day minimum rental is in the rules, but I want to really take a look at the CC&Rs too and think back to the discussion we had maybe 10 questions ago or 8 questions ago about the Callaway case. So I think this is like a loaded question with a lot of different subparts to it. So reach out to our firm so we can talk about it. It's difficult to implement a rental restriction in light of the Callaway case. It's not impossible. Sometimes grandfathering can be used to help you out to get where you need to be. But this is a question that needs to come to our firm, and we need to explore it and talk about it a little bit more. Okay, question number 19. Do you have any suggestions on how to address disengaged board members? Well, yes, I think the best thing is honesty is the best policy. So reach out to them, let them know that, hey, you're not performing, or you're not attending the meetings, or you don't appear to be prepared for meetings, and talk about it. And hopefully it's not the president, but the president probably is the chief communicator on that issue. So the president is going to need to reach out to that person and talk about that. Or maybe the management company, if the president is not in a position or not wanting to do that. Or maybe the attorney writes a letter. Lots of different options there. Okay, question number 20. If the association wants to revise an existing enforcement resolution to add that if another occurrence of the same violation happens within 6 months of the original violation, that enforcement will continue where it left off, is it a board vote, and can the revised resolution be sent via email? So I have to look at it more carefully, but based upon how you're summarizing it, I have seen associations doing this. The letter has to be set up right, though, that you send to the owner on the violation. And, obviously you want to have your attorney look at the resolution, et cetera, to make sure that the way you're doing it is proper. Okay, question 21. Our contract with the management company states our financials are ready on the 15th or after the next month. We meet every other month on the last week of the month. We have asked if we can attain the financials by the 20th of the month we're meeting, and they have denied our request. Legally, can they do that? What can we do outside of ending their contract? Let's see, the contract says, this is kind of the same question we had a little while ago. So the contract says the 15th or after of the next month. I mean, it seems kind of loosey-goosey. So maybe the contract allows them to do it this way. I would just open the lines of communication with the management company and find out, why is it taking so long? What sort of resolution can we have on this? We just don't want to be so far behind on reviewing the financials. Okay, question 22 from a homeowner. The violation and fine notice appeal process only has one option to appeal. Appeals are submitted stating why the violation or fine does not exist or extenuating circumstances along with supporting docs. The appeal will be submitted to the board in an executive session for the appeal to be reviewed. The notice does not state nor disclose the homeowner appealing can be present at the executive meeting, nor does it allow for the appeal to be heard in an open meeting. Is this an oversight or a failure to fully disclose by the community manager? I'd have to look at the law. I think the owner is the one that would have to exercise the right to have it in the open meeting. So if you want that, you certainly have the right to do that. You just need to ask in writing that you want to have this heard in the open meeting. And honestly, the policy probably should say that. So maybe the board should consider revising the policy just so that it's consistent with Arizona law. I'm not saying that they've done anything wrong. I'm just saying best practices would be to have that in the policy. Okay, question number 23. Our HOA just received the annual renewal for our walls out property, liability, and D&O insurance coverage. The new renewal premium is a 224% increase. We are a 53-member patio home built in 1973-74. Our properties are well maintained, even though they are 50 years old. Is there any provision in state law which prohibits such an exorbitant increase? Check with the state insurance commission, but I'm not aware of any. Okay, next question. Is it legal for owners to smoke marijuana at our 55-plus community pool or enclosed common areas if they have a medical card? And does the HOA need a written ban in the governing documents if Arizona law already prohibits it? I am not sure if Arizona law would prohibit it on private property, but your board can pass rules to prohibit that. Smoking should not be allowed in enclosed common areas or the community pool. Most associations already have that rule. I don't think that this is a reasonable accommodation situation. I'd have to hear more, like they need it for medical marijuana, but based on what you told me, just smoking pot at the pool is not going to work. But there needs to be a rule saying no smoking at the pool. Okay, question number 25. We are having our annual meeting at the end of this month. We are told that no business will be discussed. Voting for our new board of directors will be online and the results will be announced at the meeting. If I want a ballot to vote in person, I have to drive 20 minutes to the manager's office and vote there before the meeting. There will be no ballots and in-person voting at the annual meeting. Is this legal under Arizona law? Well, I have to hear from the other side just before I can make a good analysis on this, but your annual meeting is the homeowners meeting, and so business should be discussed. I think it's okay, voting that way. If in person, going to the office the day of the meeting, I think that's okay. So that would be considered, I don't know, the law says that you have to be allowed to vote in person at the meeting. So I think I'd have to look at how they're setting that up better to comment on that. But what they're doing seems like maybe it might need some fine tuning, but I'd have to learn more about it. But remember, even if you're having a virtual meeting, owners should be allowed to vote in person at the meeting, whether that's taking a picture of the ballot and emailing it during the time the meeting is being conducted, if it's virtual, or if it's in person, giving them an opportunity to vote in person at the meeting. That's something that is important that needs to be allowed. Okay, next question, number 26. Is it legal for the board to retroactively increase dues by 5% this year to cover a budget shortfall instead of calling a special assessment that requires a community vote? Our CC&R set voting requirements for certain increases and limits for next year's dues. So does a retroactive increase comply with those rules? I can't answer that question unless I see your documents, okay? Because I don't know if it allows the board to do this, or I don't know if a special assessment can be used for this purpose. So unfortunately, I can't answer that question. I'm just going to do a quick check right now to see how many total questions we have. Looks like we're up to about 42 questions, so that's great. Okay, next question, number 27. Our CC&Rs prohibit leases for periods of less than 30 days. They also require the homeowners to provide a copy of the lease to the association. One of our owners obtained a permit from our city for an Airbnb. What recourse do we have? Does Airbnb qualify as a business use, which is prohibited by the CC&Rs? Okay, so lots going on with this question. Let's see here. So let's start from the top. Okay, so just because there's an Airbnb doesn't mean it's necessarily violating your documents. So if the Airbnb is being leased in compliance with not less than 30 days, then it should be fine. Just make sure you reach out to the owner and tell them, hey, your leases have to be in compliance with the CC&Rs. Also, you could write a letter to Airbnb and let them know, hey, this property has these restrictions. Make sure that the listing doesn't allow for less than 30 days. I do not believe that an Airbnb qualifies as a business under the law. There's case law that says that, so it's an allowable right under your documents. Next question, number 28. After a board has voted on a new budget, can a board member who is also the treasurer change at his own discretion some monetary values in the budget? What can be done if he does so? That really shouldn't be done. That needs to be board vote. Question number 29. Considering the hierarchy of documents for an HOA, first plat, then CC&Rs. Subdivision plat has a rear setback of 25 feet for each lot. CC&Rs have a rear setback of 25 feet for each lot. Can the rear setback of 25 feet in the CC&Rs be amended and changed to a 10 rear setback, even though in the plat it says 25 feet? No, it can't. The plat needs to be amended to do that. Question number 30. I had structural damage done to my unit because of a roof leak that the HOA acknowledged and repaired. However, they're stating the lawyer is advising that I am responsible for the repairs because it's internal damage, and they're currently making structural repairs to other units because of the damage to the stucco. What can I do? Well, if the association's responsible for the roof leak, they should fix the damage. So go back to the association, ask them to reconsider, get an attorney if they won't, consider going to the ADRE if they won't, considering filing a lawsuit if they won't to pay for those costs. Question 31, given that it takes time to update the governing documents, can we proceed with rules and regulations to keep them up to date, which are board approved and always shared with the community? Well, probably not, because you can't put something in the rules that really needs to be in the CC&Rs. So it just depends on what you're wanting to do. Talk with your attorney or with our firm to help you with writing any of those up. Okay, question number 32. Our 170-unit condo association has been in existence since 1996. We have copies of all motions related to architectural issues, although no formal plan was ever written down. At least one newer board member stated that when there is a new board, they don't have to follow these motions. What is the board's responsibility regarding changes? What is the best way to write up and accept the guidelines? Just discuss all of this at a board meeting and make a vote, and those will be the guidelines going forward. Okay, our sub-associations. Question 33. Are sub-associations with the management company responsible for data collection, monitoring, and enforcement requirements separately from the master association? It depends on what the documents say, really. It's hard for me to answer that without seeing your documents. Usually the master handles those type of things, but sometimes the sub handles their own violations because they may be stricter than the master. Okay, given question 34, given the dramatic rise in property and casualty insurance for HOAs, some planned communities are considering modifying their blanket insurance policies to liability only. For the common areas, what are the legal steps and ramifications of making that change? Well, I think you really have to consider what your documents require, what are your amenities. You have to talk with your insurance agent extensively about this. So this is not a question I can answer here in this forum. This is one that we'd have to have a phone call and discuss more. Okay, we are just going to take just a short 2-minute break here. So I'm going to be right back. Just give me 2 minutes and we'll keep going with the questions. Okay, sorry about that, but just a quick little technical difficulty here and I will be right back. Thank you. Okay, sorry about that technical difficulty. We've got it all worked out and we are back. Okay, let's see. Question number 35. CC&Rs provide for a reserve fund and a general operating fund. Let's see. This cumulative reserve is intended to provide the measure of financial stability as a result of delinquent payments of assessments by owners in the association and other contingencies. Can you give some examples of other contingencies where this general operating money can be used? Okay, so your CC&Rs call for reserve fund and a general operating fund. The cumulative reserve, I've never heard of that term before, but let's just say that the reserve account is supposed to be financial stability. Okay, I don't think you guys are understanding what's going on with the reserve account. So you're thinking more like a savings account. So a reserve account is, and I think you should take a look at our cheat sheet on reserves, because that's going to define what a reserve account is. It's going to be saving for long-term capital improvements for your association. And it's not going to be for financial stability in case owners aren't paying their dues. That's the wrong interpretation of what a reserve study is for. You're kind of thinking more like a savings account type of thing. Okay, so let's see. Can you give some examples of other contingencies when this general operating money can be used? I think your association might need a boot camp where we kind of talk through the finances and just the general concepts of running the association, because I'm not sure we're on the same page based upon the language of this question. So we also have some videos that I know we've taught other classes on the financial side of running associations, and you can find those on our website at mulcahylawfirm.com. But short answer would be you've got basically two different accounts. You've got your operating account, which is the money that you pay all of your bills out of for your association. And then you have your reserve account, which is kind of like a savings account, but that money should be used for long-term capital improvements in your association. So that is defining it. You don't use reserve money to pay for shortfalls in your operating account. Only in like really dire circumstances would you do that. And I would talk to your CPA about doing that, but that is not something that you should regularly do because that reserve money should be earmarked for reserve items. So anyways, you might want to take a peek at our cheat sheet on reserves. You might want to listen to one of our videos of classes that we've taught previously on financial side of running an association to help you kind of navigate that. Or have our firm come in and do a boot camp for your board and we can talk through these issues and I can really explain how the finances of your association should be run and what the different accounts are and what the purpose are for each of those accounts. Okay, next question, number 36. Our board opened a trading account 11 months ago for mutual funds and ETFs without any board resolution. No statements were available until last month. Is this legal? How could a stockbroker open an account without a board resolution? Okay, yeah, lots of issues here that I'm worrying about. So any investment that the association is making with association's funds needs to be really safe. Playing with the money in the stock market is a little bit problematic from my perspective. Most associations are just putting their money in CDs because the interest rates have been so good in the past few years. I don't think I have really hardly any associations out of over 1,000 associations that are actively putting their reserve money with like a financial advisor and having that person trading the money on the stock market or whatever, buying stocks and bonds or whatever. There's also fees that are paid to that individual who's a financial advisor, which a certain percentage each year. So this is not something that we typically see. Also, this should have been done with a board discussion. Not that I would have agreed with it, but one board member can't just be taking money and giving it to a financial advisor to invest. So lots of problems on this one. You probably need to have a phone call with our firm so we can talk this through. Okay, next question, number 37. If the current assessment collection policy does not provide for waiving late fees for a homeowner who is deceased, is there any statute that allows for a waiver? Really, the board can make that decision. We try to get owners to pay the late fees. They don't pay their assessments in a timely manner, but we make exceptions as a board, sometimes to settle the matter, just to get them to pay. Sometimes if there's an illness or death or whatever, it's something that the board has discretion to do. Okay, question number 38. Can homeowners petition the board to solicit other management companies? Okay, I'm kind of laughing about this. Why do you think they're doing that? They're not happy with the management company, right? And so the board needs to listen, because if you aren't listening and you don't take some action, whether it's asking them what they perceive the problems are with the management company, or maybe really having a hard talk with the management company that, hey, we've got a lot of owners that are upset. Why is that? Something's going on here. And honestly, the next step is probably going to be a removal petition if the board doesn't handle this properly. So my best advice to you would be, can the homeowners petition? Of course they can. They can petition on anything. Can they force you to end the relationship with the management company? No. But red flags should be going off. Where there's smoke, sometimes there's fire. You need to look into this, and you need to tell the homeowners you're looking into this. You need to find out what their concerns are. You need to meet with the management company, and you need to report back at an open board meeting so the homeowners feel that they were adequately heard. Or I'm telling you, you will be on the path to have potentially a removal meeting because there's smoke here and they're upset. And you need to do something to address their concerns. Okay, question number 39. What specific state statute guides HOAs for voting of directors and other ballot measures? Does 1007, which is in the Nonprofit Corporation Act, apply to HOAs? Okay, so this is kind of hard to answer because there is no specific state statute that talks about voting of directors, right? First place you want to look is your documents, right? Typically it's in your bylaws, and it'll say like how many directors there should be. It'll talk about when the annual meeting is. That's when directors are elected. It's going to talk about if you have the right to nominate from the floor. It's going to talk maybe about that, maybe not. It may talk about the fact that you have to have a secret ballot. Maybe, maybe not. It just depends. Every association is different. So go to your association's bylaws and CC&Rs, what it says about voting of directors. If your documents are silent, then maybe you go to the Nonprofit Corporation Act. Like if it's silent about having a quorum, most bylaws will say what the quorum should be for the annual meeting, but every blue moon, I see one that doesn't give us an answer. So then we go to the nonprofit corporation. It's a gap filler law where it fills in the gap where the documents or the Condominium Act and Planned Communities Act don't have the answer. So it would be 10% then under the Nonprofit Corporation Act, assuming that the association is a nonprofit corporation. There are some other laws you should be aware of, like 33-1804 and 33-1248 for condominiums and planned communities. There's a statute that talks about absentee ballots. Owners can vote in person or by absentee ballot. There's a statute that talks about the notice that's required for a meeting, which is not less than 10, not more than 50 days in advance of the annual meeting. So practicing in this area, and I've been doing it 29 years. Well, actually, I've been a lawyer for 30 years, but I've been practicing in this area specifically for 29 years. This is not an easy subject area, right? Because there's so many different places you have to look and you kind of have to know the law inside and out. So it's hard for board members to navigate. So good for you that you're at this class today. Try to navigate how to elect directors by looking at your documents and looking at the Condo Act or the Planned Communities Act, depending on what you are. And then just reaching out to your counsel if you're not exactly sure, your legal counsel, if you're not exactly sure how to handle the annual meeting. Okay, next question, number 40. Generally, how soon after an HOA's annual membership meeting should the annual meeting minutes be approved and available to the membership? Well, most associations handle it this way. Annual meeting means once a year. So at the next annual meeting, which means, so let's say we have our annual meeting October 1st, 2025. At the annual meeting in October 2026, the members approve the minutes from last year's annual meeting, okay? That it's perfectly legal for the association to not show those minutes to the members until the next annual meeting when you send out the notice for that meeting where we ask them to vote on it by absentee ballot or we ask them to vote on it in person. That's pretty normal. Some associations will have the annual meeting and then maybe 60 days after the annual meeting, they'll send out like a draft version of the annual meeting minutes just as an FYI and just indicate that those will be voted on at the next annual meeting. You don't have to do that, but that's something that some boards do. So generally speaking, how soon? It's usually a year at the next annual meeting. Okay, question number 41. We're down to our last 4 questions. Per our governing documents, the board has full authority for budget development and spending decisions. Some homeowners believe the board should establish a maximum amount for capital projects above which a homeowner vote would be required. The board sees risk in this concept since it does not align with our documents and the criteria for setting the amount can be arguable and arbitrary. Is there any wisdom in inviting homeowners into this spending decision process? Okay, so under the documents of this association, the board makes the budget, right? That's kind of how every association handles it. Usually the manager comes up with the first draft and then the board starts discussing it at an open board meeting and you talk about it for a couple meetings and then by October or November, maybe December, you're ready to vote on it. So some homeowners think that the board should do a certain thing with the budget and the board doesn't agree with that, because they think that it doesn't align with the documents and having an amount that's requested by the owners, like a cap amount, that's not something that's required by the documents is going to really strap or limit the board. And I kind of agree with that because if you're going to have limitations on the board's authority, it needs to be in the documents. It can't just be like something that the homeowners are requesting. If they want to request it, that's fine, but it needs to be an amendment to the documents. Is there any wisdom in inviting the homeowners into the spending decision process? You should be discussing it in an open board meeting, but you don't have to do what they're asking you to do because it's not in your documents. Okay, question number 42. What are your thoughts about the board disclosing that it is receiving legal advice? Obviously, board members should refrain from discussing advice of counsel as that could risk a waiver of the privilege of confidentiality. However, it seems that the board can disclose in some circumstances that it is receiving legal advice on a matter. If there is pending litigation that has settled, wouldn't it be prudent to advise that the matter has been settled? Okay, great question. This is kind of like I'm going to call like a tightrope question. because you're on this tightrope and it's like, how much do we disclose? Can we disclose it if there's a confidentiality agreement? Are we waiving our attorney-client privilege? So here's the best thing that I can tell you to do. Talk with your attorney and be like, hey, how much should we disclose of this? Or what are we required to disclose? Or are we not allowed to disclose this? Or what do you recommend? That's the best policy. Your attorney is your partner. Your attorney is your teammate. And if a client says to me, like, let's say we settled this lawsuit and it's a controversial lawsuit. And let's say, like, I have a case right now where there's been a very positive ruling in a matter, and the whole community is aware of this issue. But the case isn't over. There's only been a positive ruling, and trust me, it's a great ruling. But the case is not over. There still needs to be a discussion and briefing on the kind of the last issue of the case. And so sending out a "we won" type email is not prudent, not a good idea, because the case is still pending. I don't want the judge saying that. So listen to your attorney's advice. And in my case, that I'm just giving an example of, and I've had this with a lot of other cases too, I wouldn't say anything at this point. Say the case is still pending. And if you do win a case, don't gloat. Be nice, be professional, have the attorney write it up, keep it short. That's usually how I'm approaching things. It's okay for the board to say, hey, we have a lawyer, we're consulting with the lawyer on this, but really talk with the board, talk with the attorney about what's the best way to handle homeowner inquiries about how involved legal is or what's happening on a case. Okay, question number 43, down to our last 3 questions. I have asked in writing for financial documents, contracts, and invoices for the past 5 months. The board and management company have either not delivered or delivered docs for other properties. What can I do to get the necessary documents to review? I will send a demand letter later today. Well, you're not getting the documents, right? You're asking for financial documents, contracts. You are allowed to see contracts, but they can redact how much the vendor is being paid under the law. I give them one last chance and say, hey, I've asked you on this date and this date for these documents. I attended a seminar this morning where a lawyer who's well-versed in Arizona HOA and condo law told me that you should be giving me these documents. I understand that the contract, the amount that's paid to the vendor can be redacted. It's fine that you redact it, but I'm asking for these financial documents and the contracts, fine for you to redact them. If you don't get them to me within 10 business days, I'm going to do one of these things. Go to the ADRE, file a complaint, hire an attorney, or file a lawsuit to make you do what you're required to do under the law. Okay, last 2 questions. We have 2 board members' terms expiring at the end of November. We also have 2 applicants to fill those positions. Can those applicants be appointed by a majority of the board, or do we need to have an election with a quorum of homeowners at our annual meeting? So this is a good question. If the term's expiring, even if you only have 2 candidates running, you still have to go through the whole process of having the annual meeting, putting those 2 people on the ballot, and having them officially elected. That's just what the law says. Okay, last question. The FHA has a rule not to loan to a facility with a membership of over 50% non-owner occupancy. Has this rule, to your knowledge, been challenged? So good question. So actually, the FHA keeps changing their requirements. It's crazy how often they're changing their requirements to do, government loans for properties. They focus on how much money's in the reserve. They focus on how many rental properties there are. These are all things that they see as things that affect the financial stability of the association. So has that rule ever been changed or challenged? I honestly don't know the answer to that. I think that the government has the right to pass those type of rules. It's a loan, basically, they're giving, and they can change their loan criteria as long as it's reasonable. So I'm not aware of any challenges on it. And the requirements change often. So, it's kind of like a sliding scale. Maybe it changes from time to time, so you don't really know. But I don't think that it's something you can challenge because there's another way you can get a loan from a private bank. You don't have to go through Fannie Mae and Freddie Mac to get a loan. So anyways, hopefully that answers your question. Okay, so we're at the end of our class today, and we fortunately did it in 1 hour and 6 minutes, which might be an all-time record for us. So we had about 87 viewers today at peak, which is awesome. We just wanted to let you know about 2 more classes that we have coming up this month, including one in-person class in Scottsdale next week. I personally am going to be teaching at the Scottsdale Neighborhood College on Wednesday, October 8th from 1 o'clock to 3 o'clock p.m. at the Mustang Library in Scottsdale. And we're going to be talking about practical strategies for aging HOAs and condominiums, infrastructure problems, special assessments, deferred maintenance, you name it, we're going to be talking about it. How to help communities that are 20 years plus or 10 years plus and that have problems. And it's going to be a really good class. I think it's the first time I've ever taught this class. So we're looking forward to teaching this class and hope that you can join us if possible in person. If you are interested in joining the class, you can go to our website. And there's more information on how you can sign up there. Our website, again, is www.mulcahylawfirm.com. Okay, we're also going to be sharing a link probably with you. Also, if you want to register for the class, we'll be putting a link here in the Zoom and on Facebook Live as well. And also, we're going to be having a virtual class, which is part of our Neighborhood Services Virtual HOA Academy. We have this class just like First Fridays. We have that class every month on the 3rd Tuesday of the month at 11 a.m. And that class is going to be on Tuesday, October 21st, 2025. It's going to be our October class, which is our 10th class of the year in 2025 of our Neighborhood Services Virtual HOA Academy on Zoom and Facebook Live. And we're going to be talking about large capital improvement projects and assessments in that class. So we're going to be talking a little bit about should associations increase their assessments annually? Really good discussion right now because we're talking about budgets. How do we increase assessments? How do we do special assessments? And we're also going to be talking about how to manage a large capital improvement project, which I'm in the throes of right now with my association. We're in the process of putting together a $5 million capital improvement project. So I'm focusing on that firsthand. But also help our clients from a legal perspective on all aspects of that, like financing it, if you have to get a loan, if you have to do a special assessment, managing the contractor process. It's necessary, it's exciting, but it's not always fun. So we're going to talk about the legal aspect of doing that. So I hope you'll be able to join us for that class on October 21st. Thank you again for being here today. We appreciate having such great participation. And I hope you have a great month of October. Happy Halloween if I don't see you at our Neighborhood Services class, and look forward to seeing you again in November. So take care, everybody. Have a wonderful weekend. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.